falsely accused of domestic violence can destroy your freedom. And the worst part, many don't even know where to begin defending themselves. I'm going to walk you through 5 effective ways to fight back if you're facing domestic violence charges in California. Hi, I'm Nana Knight, and I've spent over 15 years in the courtroom, first as a prosecutor and now as a California State Bar board-certified criminal law specialist and a defense attorney. If you need to speak with an attorney for an urgent matter, give me a call at 408-877-6177. Let's dive into it. Number 1, challenge the evidence. In many domestic violence cases, the prosecution relies on statements made in the heat of the moment, such as spontaneous statements or statements that were made on the scene. Maybe the alleged victim told the police one version of the story and later changed that version, or maybe there were no visible injuries or other witnesses or other corroborating evidence and no follow-up by law enforcement. That's where we start pulling things apart. We look at the 911 calls, any body cam footage that the police collected, including the police reports and the photos to spot any inconsistencies. Sometimes when you're accused of domestic violence, this simply doesn't match the evidence that was collected in your case. For example, if someone claims you struck them repeatedly, but there's no sign of injury and there's no sign of traumatic condition, or the injuries don't line up with their story, we can use that to challenge the credibility of the alleged victim or the complaining witness and challenge the entire case. A big part of our job is showing the judge or the jury that the prosecution's version isn't the only one that exists. It also includes showing the weaknesses in the prosecution's case. Number 2, another defense we use is mutual combat. Domestic violence charges often require the prosecution to prove that you willfully harmed someone. But not every injury is the result of violence, and maybe you were just arguing and you didn't touch the other person and they were coming forward, lunging it, and they ended up tripping and falling. They sustained injuries, and that's not an injury that you caused. It was an injury that they sustained during the course of trying to attack you in that situation. We had a case where the injuries on the complaining witness were caused by their pet cat days before the arrest. You can have a situation where you're trying to leave the room, but the other person prevented you from leaving or attacked you, and there was mutual combat. Or maybe there was some physical contact, but not in a way where you willfully inflicted a physical injury on the other person. Your state of mind or your intent does matter, and in domestic violence cases, it's not always black and white. We present your side clearly and carefully, showing what happened and showing that the incident wasn't criminal behavior. It was a misunderstanding or an accident. It was a case of self-defense or mutual combat, or even just an emotionally charged argument that never rose to the level of violence. Number 3, exposing false accusations. Unfortunately, some domestic violence allegations are flat out false because they come from a place of anger or revenge or fear of losing custody in a divorce or a custody battle. Other times, they're a way for someone to gain leverage in a legal case or avoid the consequences for something else. False accusations happen more often than people think, and when we handle these cases, we dig deep into the background. Has this person made similar claims or allegations in the past against you or somebody else? Do their social media posts contradict their claims? Did they say something completely inconsistent to a friend or a family member after the incident? Are there any text messages or voicemails, for example, that tell a different story? The truth has a way of surfacing when you know what to look for. We use those details to expose what's really going on and fight to clear your name. Number 4, violation of your rights. Sometimes the police don't investigate properly, and if you were arrested without probable cause or interrogated without being read your rights, or if you were searched without a warrant, your rights may have been violated. And when your rights are violated, it could lead to evidence being thrown out or even the whole case, the entire case being dismissed. And that's why we scrutinize every step of the process, every piece of evidence. We review how the arrest was made, how evidence was collected, the type of evidence that was collected, and whether law enforcement followed proper procedures. Did they take shortcuts, for example? The government doesn't just get to bend the rules because the charges are serious. We make sure that your constitutional rights are protected from start to finish. Number 5, claim self-defense. Not every act of force is illegal if you are defending yourself or protecting your children, for example, from harm. You may have a valid claim of self-defense. We had a situation one time where the complaining witness got angry at the client and came running from the other side of the room to attack him. The client held up his hand and pushed the complaining witness away in self-defense to protect himself and his child. This is an example of someone using self-defense. But here's the catch. You can't just say you were defending yourself yourself. You have to show that your actions were necessary and reasonable under the circumstances, and you didn't use more force than necessary to defend yourself. We work with you to build that case, to build your defense, whether that means bringing in other witnesses, other witness testimony, or reviewing past incidents of abuse, or demonstrating that the other person was the initial aggressor or they have serious credibility issues and should not be believed. Self-defense is a legitimate and powerful defense when it's used correctly, but it needs to be part of a well-prepared legal strategy. So if you're thinking about pleading guilty just to get it over with, think again. A domestic violence conviction in California carries serious long-term consequences. You could face jail time, you could face fines, mandatory domestic violence offender classes, 52 weeks in length, or loss of gun rights, restraining orders, criminal protective orders, and permanent damage to your record. It could affect your job, your professional license, and your custody rights. And even if you avoid jail, the stigma could follow you for years. That's why it's important to take these charges seriously and fight them with everything you've got when you've been falsely accused. Just because you've been accused of domestic violence doesn't mean you're guilty, and it definitely doesn't mean you're alone. There are real proven strategies, real proven ways to defend yourself against false accusations. And when you have the right team in your corner, you can move forward with your life. And if you've been arrested or accused of domestic violence in California, you shouldn't wait to get help. The sooner you act, the more options you have, and the stronger your defense could potentially be. If you need someone who understands the system and knows how to protect your rights, give us a call at 408-877-6177. And if you found this video helpful, check out the next video for more information on how to beat your domestic violence case if you are falsely accused.